and also a faculty member at the Johns Hopkins Furman Institute of Bioethics. Much of my work takes place at the intersection of reproductive justice, biomedical research regulation, and public health. And for some time now, I've been specifically focused on issues related to addressing the legal barriers to including pregnant people in research. Now, most of us who've spoken at conferences dread giving the talk right after lunch. You're full, your minds might be wandering, and you might, I hope not, doze off. And that can be especially true, I found, if the subject of the talk is law. So let me tell you at the outset what I'm going to say at the end, just in case. Number one, there is a deeply entrenched myth that it is legally impermissible to include pregnant and lactating people in research. Yet all of us know that clinical trials with pregnant and lactating people take place, and while it might not be as common as we like, there are legal ways to do ethical research. So we need to understand why this myth persists and engage in outreach and education to correct it. Number two, research sponsors and other stakeholders, including researchers and academic institutions, often point to two factors as the primary reasons that they don't do research with pregnant and lactating people. With regard to those who are pregnant, human subjects research regulations, and specifically Subpart B. And with regard to both pregnant and lactating people, concerns about liability, which we've already heard some about today, for the potential harm that might result from a pregnant or lactating person participating in clinical research. So the bad news is that the legal landscape is far more complex than just those two things. A variety of legal factors can actually influence stakeholder decision-making throughout the research pathway. And we know that in order to understand those nuances, we really have to break down decision-making at each point along the research pathway, from product development all the way to marketing. But there's good news, and the good news is that these potential barriers to inclusion are in some cases perceived and not necessarily real legal barriers. We have to shine more light on the relevant legal issues, though, so that we can stop fearing what might actually be legal shadows and begin to concentrate on what are actually concrete legal problems. And third and finally, we need to think about the inclusion of pregnant people in research as a public health issue. I say this as someone not necessarily from a legal perspective, but there are legal reasons to think so, but as someone who cares a lot about issues related to reproductive justice and public health. There is an important reason to invest in a public health research pathway. Even outside of the research enterprise. And there are lawyers who are knowledgeable about this space who can help stakeholders engage in really creative risk management strategies to do this work. So each of the potential barriers that I'm going to point out to you have answers. They can be addressed. Those are the three main takeaways. Hopefully you'll stick with me now as we go through the legal terrain. So we're going to map the landscape, and hopefully you will forgive me for what are going to be road signs that follow. I have a daughter who is now in driver's ed, as I was telling Ruth earlier, and I'm paying a lot of attention to road signs. And as we map the legal landscape, I thought they might be helpful for us as well. So the first is a cautionary note. I want to say a few things about the complexities of the legal terrain so that we don't inadvertently make conclusions that might not actually be playing out on the ground. Secondly, it's important to look at what those legal factors are along the research pathway that can slow or halt inclusion of pregnant and lactating people in research. Third, we have to figure out what the pathways forward are. And finally, we need to anticipate the legal changes ahead. So the first and most complicated, of course, is the cautionary note. The map that I'm going to present to you over the next 10 minutes or so is not complete, and it can't be in 10 or 15 minutes, or probably even in a day or two for that matter, because there are so many different legal regimes that make up the legal terrain that implicates and is implicated by research with pregnant and lactating people. But here are a few. The law views pregnancy and lactation differently. As I mentioned, and as you know, there are specific human subjects research regulations related to pregnancy. Liability for harm also looks different. Prenatal exposure resulting in harm has a different legal regime than postnatal exposure resulting in harm. So pregnancy and lactation can play out very differently as stakeholders try to make legal decisions. Or, for that matter, make decisions and they are thinking about legal factors. Drugs and vaccines are also part of very different legal regimes. We know that they're different from an FDA drug development and approval process, right? Even something as obvious as filing an NDA versus a BLA, but the liability schemes are also different. So for drugs, for example, we know that this often falls to a private party, whereas in the context of vaccines, there is a federal compensation program fund that can fund research-related and other kinds of injuries. And finally, as many of us learned during the COVID pandemic, there is a large difference between non-public health emergencies and public health emergencies, both in terms of research development and approval processes. The emergency use authorization is an example, but also in terms of liability schemes. So in a public health emergency, there's immunity from liability for activities that are related to medical countermeasures, even if they're not vaccines, right? So for that reason, and I'm happy to come back to that slide later if there are questions, the upshot is we really can't comprehensively chart the landscape now. So my focus is going to be mostly, but not exclusively, on pregnant people in research and development and approval of small molecule drugs when we're not in a public health emergency. So in an effort now to evaluate those claims and to deepen our understanding of the influential role that legal thinking and legal decision makers too play throughout that clinical research pathway, several of us conducted a series of consultations back in 2017 with 20 legal experts who have intimate knowledge about different facets of the research enterprise. They represented public and private and academic sectors. They included prominent legal practitioners, legal scholars, regulators with deep experience in this space, former and current general counsels, outside legal counsels to pharmaceutical companies, et cetera. The question we wanted to know an answer to is, why is this research not happening more often? Why are so many pregnant people, that was the focus, not lactation, excluded from research? And what we learned is that lawyers and regulators have the potential to be involved in decision-making that influences the conduct of research at every point throughout the research pathway, from conception of the study question, through the product idea, through to the reporting of findings, and ultimately the final product approval and distribution. And specifically, there are 5 factors worth highlighting, I think, from that research, the citation of which is at the bottom of that slide. The first of these has to do with regulatory ambiguity. And when we talk about regulatory ambiguity, there are a few things that we're thinking about, but first is to get back at that myth, this myth that the research can't be done. We know from 45 CFR 46 Subpart B that there is nothing in that regulatory language that precludes the conduct of research with pregnant people. At the same time, there isn't anything that affirmatively requires it. So an IRB has the opportunity to say, as many do, that it's okay to exclude pregnant people in certain situations rather than have to justify their exclusion. So flipping the premise would be important, but as the regulation is currently written, one might say it is a bit ambiguous. So the current federal regulations, Subpart B, neither require the inclusion nor penalize the unjustified exclusion of pregnant people in research. And there are a lot of ambiguities. For example, minimal risk that are open to wide interpretation in the face of regulatory ambiguity. And without a clear directive to include pregnant people in research, stakeholders tend to apply, especially legal stakeholders, rather conservative interpretations, right? And that's often what's happening in this context. We can talk more about that as well as we go forward. Perceptions of liability. While liability is frequently cited as the single most common reason that decision makers exclude pregnant people from research, it is important to note that based on most of the evidence available, and far, far more needs to be funded and gathered, stakeholders' fear of liability seems to be outsized compared to the actual risk of liability. Harms to pregnant subjects and fetuses and offspring are actually far more rare than the fear that many of that occurring have. So although pre-market testing is not risk-free, and I don't mean at all to insinuate that it is or that there's no risk, liability in that setting is limited to the size of the research population. And it could be mitigated by obtaining fully informed consent from each participant in research, by having something like indemnity or trial insurance or some other plan for research-related injuries. By contrast, legal risk might increase substantially after a drug is put on the market if, for example, adverse events occur in a sizable patient population that was excluded from the research. And we've seen some of that happen in the context of psychotropic drugs. So it's important to note that the fear of another thalidomide actually has things entirely backwards. Thalidomide happened because there were no pregnant people included in research, right? And so that's the scenario I'm describing, right? That we might actually be engaging higher risk levels when we don't include pregnant people in research than if we were to include them and have a smaller pool of risk to manage and mitigate. Risk management challenges. Lawyers are, and should be, good lawyers, experts at risk management. They should thoughtfully engage in risk mitigation. The question they should ask themselves is, how can we do this? So the question is, how can we do this? And there are a lot of options that PregLac in particular has put on the table. I have spent quite a deal of my own research writing about research-related injuries in various compensation programs. Certainly PregLac considered the vaccine injury compensation program as one option. It isn't the only or maybe even the best option for indemnity. Professor Anna Mastriani, who is on the panel that's going to follow this, will talk a little bit about an academic center indemnity program because they can be more localized. But trial insurance, self-indemnity, and a variety of other compensation programs for research-related injuries could exist and actually do exist in many other settings. In fact, most other countries around the world require compensation for research-related injuries, and U.S. researchers cannot conduct research in those countries without first procuring trial insurance. Risk shifting and the learned intermediary doctrine. There was a very interesting case out of Washington State that the Supreme Court there just decided this week, suggesting that if a physician prescribes a medication to a patient, that physician has the onus on them to describe any risks that may occur in the patient from the result of the ingestion of that drug. not the pharmaceutical company who made the drug, but the physician. And the Washington Supreme Court is consistent with all but one other state in the country, which has a slight exception. With the exception of New Jersey, in every single state, whatever risks, right? I know you physicians are sitting there going, oh, yeah, and other healthcare providers, right? It is the law, and this is why there is a fear of liability, right? Because if you prescribe a drug and something happens to your patient, the learned intermediary doctrine shifts the risk from the pharmaceutical company downstream to the healthcare provider. It's on the healthcare provider to describe the risks, but that is a heavy burden to bear when you do not have the requisite evidence to make that kind of disclosure to your patient. So what's happening in the status quo is what in law we would call legal risk shifting. Industry, as currently organized, is legally able to shift the risk downstream through this intermediary doctrine, the result of which is they are largely liability-free, not exclusively, and I don't want to oversimplify. Again, note the caution sign at the beginning of the talk. But again, this learned intermediary doctrine is really a critical part of what's not being talked about. Finally, there are venue-specific laws that can slow or halt inclusion. I'm going to talk at the briefly in a few minutes about the big elephant in the room, right? Justice Alito's forthcoming decision. But before we get to that, there are venue-specific laws already in every state. In every state, there are laws regulating any kind of harm that can occur to a fetus. And here I'm not talking specifically about abortion. It could be fetal homicide as a result of a car accident. But these laws can be interpreted in such a way that a legal decision maker or someone else worried about liability in a particular state could look at a whole host of laws that invoke the word fetus in a criminal statute and decide that that is enough reason to step back from that kind of research. So paths forward and anticipating the changes ahead. There are a variety of opportunities, I think, to move forward from where we are now, and a lot of them have already begun to be undertaken. Regulatory revisions, we know we saw the word vulnerable disappear from the common rule. That was an important step forward. But right now, the HHS regulations and the FDA regulations are not in sync. There we go. Are not in sync, and that is sufficient to cause some reluctance. The FDA is moving important regulatory guidance forward, but until we have a statement that requires a justification for exclusion of pregnant and lactating people from research, right, it will still be possible for those who fear any kind of legal risk to take the more conservative interpretation of any regulation. That regulatory guidance then is really critical in helping decision makers throughout the research pathway make decisions that are more inclusive. Finally, as I mentioned before, there needs to be a great deal of research and education related to liability. There is only a very slim bit of knowledge in this space now, and it needs to be greatly augmented. As Preglack noted, it's important to investigate the feasibility of various injury compensation schemes. There are a number that might be possible. The Vaccine Injury Compensation Program, as I mentioned, is just one. And then finally, something that I think has not quite gotten the attention it deserves is the variety of legal and financial incentives to shift industry's perspective on doing this research. So instead of thinking about this from a risk mitigation perspective, think about this as a stockholder, right, of a major pharmaceutical company. And that is, there are financial incentives available to do other kinds of research. Think about the Orphan Drug Act or research on rare tropical or other diseases. These, through FDA, are incentivized. You can fast track your next big blockbuster drug. That can be worth billions of dollars. So if we incentivize this research and create and require guidance or regulations that require a justification for exclusion of pregnant and lactating people, that could move us significantly further ahead. At the same time, there is a huge change ahead that I think is the elephant in the room, and that is what happens in the next week or two when almost certainly Justice Alito's Supreme Court majority opinion will come down in Dobbs versus Jackson Women's Health Organization. That's the case in which at least the leaked opinion suggested that Roe v. Wade and the subsequent case, Casey versus Planned Parenthood, will be overturned. And if those cases are overturned, as it appears they will be, that has significant implications for the status of the fetus and the ability of states to give greater status to the fetus in a whole variety of civil and criminal law. If that happens, we might query whether Subpart B as currently written will stand at all. And I see my time is up, and I'm sort of in the grace period. So I know that's a hard place to stop. For me too. But we're going to stop because we have a great panel coming up, and we can talk more about this as the panel unfolds. Okay, so I'm now going to call the panelists to come up. Thank you. All right. So it's now my pleasure to introduce our three panelists who can speak more specifically on some of these issues. To my left or right is Professor Anna Mastriani, who is the Charles I. Stone Professor of Law at the University of Washington School of Law. Her work examines the intersection of law, bioethics, public health, and health policy, with a special emphasis on the legal and ethical challenges associated in conducting research with pregnant people. Catherine Sewell, who is all the way at the end, is a board-certified obstetrician and gynecologist and also acting deputy director and deputy director for safety in the Division of Urology, Obstetrics and Gynecology at FDA. And seated in the middle is Jeff Roberts, who is Associate Vice President of Vaccine Clinical Development at Merck Research Laboratories. Prior to joining Merck in 2021, he was Associate Director for Scientific Affairs in the Office of Vaccine Research and Review at the FDA. So I will turn first to Professor Mastriani.
Thank you. It's a real pleasure to be here. I also, as Ruth mentioned, I was the study director here at the Institute of Medicine when we did that first initial study on the inclusion of women in clinical studies that was funded by NIH and also with additional support from the Rockefeller Foundation. So it's nice to be here on, hopefully, you may not see this as the other side if you're just new to this area, but I'm like, yay! Okay, so I have been asked to share my thoughts on factors in the IRB research review and approval pathway that may mitigate or overcome some of those well-documented barriers to conducting research with pregnant participants. And I'm going to offer my three insights derived from a qualitative study that was published in 2020 that I conducted with my law colleagues, including Dr. Henry, as well as Sarah Wicks and Robbie Franceschini. And our study was conducted at the University of Washington, which is not only my home institution, but more importantly, is a major academic research institution. It is among the top recipients of federal research funding, and it has a documented record of successful research involving pregnant participants. We interviewed investigators, IRB staff members, university administrators, and ethicists who had successfully conducted or reviewed research with pregnant participants. And our goal was to extract and share strategies for facilitating the conduct of research with this complex population, just like I'm doing now. So again, yay. Okay, so first, let's see. Okay, so first, the UW, I'm going to call it UW, and you're just going to have to go with me. It's University of Washington. UW has a well-disseminated statement of institutional commitment to research on pregnant people. Specifically, and I quote, the UW supports the policy of providing pregnant people with the same opportunities as non-pregnant people to participate in research unless the individual meets exclusionary criteria or the study poses more than minimal risk to the fetus. In other words, the starting point, the default position at the UW begins with a presumption of inclusion rather than exclusion. Now, as Dr. Henry pointed out, regulatory ambiguity as well as inconsistent application of Subpart B's requirements are often cited as impediments to this research. But another way, a lawyerly way of looking at those same concerns is that the ambiguity offers opportunities for bounded interpretation. And the UW has recognized the flexibility that is inherent in the regulations. So there is an agreed upon understanding of regulatory interpretation that's reflected in both policy as well as consistent implementation. And that begins with widely accessible, you can look them up yourself even, widely accessible web-published standard operating procedures and worksheets. And these institutional interpretations of the regulations can guide researchers and reviewers and administrators through each component of the regulations. Washington also provides training to all IRB staff and committee members on regulatory definitions and interpretations of risk. And that goes beyond only considering the risk to the fetus. So it includes accounting for risk to the pregnant person and fetus of not conducting the research and considering not just the absolute risk, but the risk in the context of the protections provided in the protocol. Further, before an investigator submits a protocol for review, IRB staff offer consultation opportunities. And over time, this transparency and consistency appear to have engendered a climate of mutual respect and trust between the investigators and the IRB that really stands in contrast to the traditional narrative of the IRB as obstacle. And one more factor that may play a role in promoting this research. The university is relatively unique, very unique, among academic research institutions in having a long-standing self-funded compensation program for research injury. This program offers medical and other assistance for injuries that are, quote, more likely than not caused by UW-conducted research. It was described to us by our respondents as a program that not only helps research participants, but also protects researchers. We're told also that as a whole, the UW has fewer research-related lawsuits and tort claims than do comparable institutions. Okay, last slide. So some takeaways on the pathway forward. Developing and consistently implementing formal written policies, a shared commitment to this research, training of the IRB on risk assessment, consultation opportunities with the IRB, and the availability of compensation for injury. Oh, and I wanted to mention that the IRB frequently and routinely uses and includes an obstetrician in review of those protocols. So those are just a few of the insights that we gleaned from our study on regulatory facilitators for this research. You can read the full report of our findings in that article that's up on the slide. And I'll leave you with a quote from one of our respondents. What I say all the time is that the regulations have a path for this. Let's walk down that path. So thank you for your time.
Hi, I'm Jeff Roberts. I'm now at Merck, as I indicated.
Am I supposed to be going? Either way. Okay, that's fine. Go ahead.
Do you want to go ahead?
See my slides?
I don't have it.
I think
Maybe I can go over your slides. They look great. Do you want to go?
Oh, sure.
Well, good afternoon, everyone. I want to thank the organizers for inviting me here today. And it's just been a really exciting and engaging discussion, and I'm energized. So why are my slides going like crazy? Okay, that's good. You can start here. So I don't have any financial disclosures to report, and I want to just make it clear that the views that I am presenting today are my own, and they do not necessarily represent an official position of the FDA. I also want to say that I'm aiming to use as inclusive language as possible when it comes to gender, but I'm acknowledging that many of our guidances and the regulations use the word women. Working. Okay, so you have been working with my FDA colleagues for years now, so I just want to amplify the message that we've been giving you is that FDA is committed to advancing research in pregnant and lactating people. Have been active, as I said, with you in many national efforts, most recently PregLac, but also just about a year and a half ago, FDA convened a workshop with Duke Margolis on the scientific and ethical considerations of including pregnant people in clinical trials. And then just last month, the Office of Women's Health and JHU CERSI convened a conference on leveraging real-world data in maternal health. And actually, the keynote speaker was the FDA commissioner, which I think says a lot. So I just want to discuss the regulatory considerations. What is going on with my slides? The regulatory considerations for drug research and development for pregnant and lactating persons, and discuss some selected FDA efforts to advance clinical trials and collect data in this group of people. And we've talked about some of them already. So we've put out several guidances in the last few years. Is there something going on? It's like possessed. So you have seen as part of the briefing booklet, the scientific and ethical considerations for the inclusion of pregnant people in clinical trials. So this guidance will discuss sort of if a person becomes pregnant during a trial, what are the considerations in terms of weighing benefits and risks of allowing her to stay in the study or them to stay in the study so that we can at least get some PK data. We have a post-approval pregnancy safety studies guidance, which more and more now we are requesting or requiring that sponsors do 2 post-marketing studies, one being a PMR, which is a prospective cohort, like a registry, and then the other complementary studies, which really can kind of help close the data gaps, is like using EHR data. I also want to point out, since we have been talking about equity, that FDA also does have a guidance about increasing diversity in clinical trials. And we have a guidance of clinical lactation studies and considerations of when those studies would be required, how to design them. This is really funny. It must be on a timer of some sort, maybe. How to design them and then how to interpret the results. So we've talked a lot about Subpart B, and we've talked a lot about minimal risk. It's a good thing I'm really calm. We talked about minimal risk and how that's defined and the ambiguity in that. And we also earlier talked about the consent of fathers if there's no prospect of benefit to the fetus. And, considering that today's family structures are so different, I think this is something that we need to consider. We've already talked about the common rule and the exclusion of the word vulnerable from the regulation. Thank you. You can run the slides for me. I'm almost done. But so FDA is working to harmonize our regulations with the common rule to remove the word vulnerable from our regulations that govern human subjects protection. Okay, next slide. Maybe I'll let you do that. Great. I just want to highlight a couple of things that we're working on for the future. So FDA has PDUFA 7 proposed commitments, regarding pregnancy safety, and some of those regarding Sentinel, which, as you know, is our medical products active safety surveillance system. The good news is now that mother-infant linkage is over 79%, so that makes it really useful, increasingly more useful. So by the fall of 2023, we're to host a public workshop on post-marketing safety studies in pregnant people. By 2024, we're supposed to publish a workshop report describing the proposed framework, and then by the fall of 2027, update the proposed framework and develop a guidance for a standardized process in determining the necessity and type of pregnancy post-marketing studies. Next slide, please. I also would just want to mention briefly Cure ID and the Cure Pregnancy Treatment Repository. So you may have heard of Cure ID. It's basically collecting information on drugs that are being repurposed to treat infectious diseases. They have a web application, and you can download an app. The information is generally collected from literature, but also providers can upload their experience using repurposed drugs. And it has been in infectious diseases now, but we have pregnancy-related questions. So still, most of the data that we have in pregnancy is for infectious diseases in pregnancy, but we are expanding with the goal of looking for where the greatest treatment needs are in pregnancy so that we can capture those data. Next slide, please. So we've been talking a lot about making the inclusion of pregnant people the default, where appropriate. And asking for a justification if pregnant people are going to be excluded. And FDA can certainly facilitate those discussions when we're talking with sponsors in the pre-IND or IND phase. And it can also facilitate discussions with IRBs so that we can guide researchers. We can publicize what our therapeutic areas are that we think are priorities to kind of make an initial focus. And then we've also talked about targeted incentive programs and requiring a PregLac study plan. So I wanted to thank you all and thank my colleagues at the FDA as well. Thanks. I'm going to get rid of this.
Catherine, I'm so glad I didn't take on trying to present your slides.
Yeah, right.
Although I do wish I had one of the normal slides I would always have when I was presented for the FDA, which is to say, these are my own thoughts and don't necessarily represent, because that's true of now where I sit at Merck as well. You know, for the most part, I'm going to be talking to you with my regulatory hat on. So this doesn't represent Merck's official positions. Just want to make that really clear. I thought what I would do is tell you a little bit about, kind of from a broad perspective, how things progressed with respect to use in pregnancy with the COVID vaccines from an early, as we were sitting at the FDA early on. So we knew that the products were going to be used in adults and that use inadvertently or intentionally in pregnancy was inevitable. And so when we wrote those first guidances to talk about the 50% efficacy with the lower bound of whatever, we managed to get into that guidance as well, specifically talking to industry and saying, we encourage you to remove the requirement for contraception from these pivotal phase 3 trials, because we can anticipate that women are going to be vaccinated before they're aware that they're pregnant, to a very large degree once this becomes a national program. And if we can get these kinds of data in a randomized, blinded, clinical trial, it will be the best possible safety data we can have to inform what we know is going to happen. And so, in addition to making this recommendation and guidance, we talked with industry and encouraged them to do these things and to also begin to do repro-tox studies early, to plan to do specific studies in pregnancy early. And it just didn't work out that way. I think everyone's hair was on fire because of COVID. If you rewind the tape a little bit and remember where we all were. So it's understandable. And yet, this is how it plays out in the vaccine world every time. Pregnancy is an afterthought. These reprotox studies are done way late in development. Specific studies in pregnancy aren't done until post-licensure. And so, I think it's like a microcosm of how vaccines are typically developed in pregnancy. And this was what motivated us in CBER, in the Office of Vaccines, working with folks like Lynn and Layla and Catherine to think about, do we want to institute some sort of pregnancy and lactation plan such that we would be asking industry at the beginning of their development plan, when they come to FDA and propose under pre-IND or when they come in under IND, to say, tell us, what do you anticipate use will be in pregnancy? And given that, what's your plan to develop this product so that we have adequate safety and effectiveness data to support use? It's a delicate thing because, in some ways we would be veering into legislation in the form of the Pediatric Research Equity Act, and we don't want to be seen as legislating when we're sitting, in the FDA. And I'm not sure that creating those kinds of regulatory structures are quite the answer either. It may be something more like, just anticipating that you justify not including pregnant women rather than the current paradigm. I'm not sure what the answer is exactly, but that work is ongoing, and I think we all have to recognize that it's case by case. There's the legal aspect of this too, and it's of great interest to me now where I sit in industry. I don't have a good sense of that quite yet, and so I'm really interested to hear the rest of this panel discussion and especially the next one, because it's, now sitting here, I think I'm going to have a better sense, kind of soup to nuts, what are all those barriers and where can we really press forward in a way that makes sense. So really looking forward to the rest of this discussion. Thanks.
Well, thank you all. We have about 5 minutes for discussion just that we're going to have and share with you about the few things that we've had an opportunity to say in the last little bit. Then we're going to have another panel that is also on issues related to law, in which we'll get perspectives from various stakeholders about their experiences. After that panel, we will have a Q&A session that's much lengthier, in which all of us from this panel and the next panel will be available to take your questions. But one of the things I think might be interesting for everyone to hear more about is from your experience either studying the research pathway or being part of it from where you sit. What do you see as barriers that other people might not know about who aren't in the position where you sit, or facilitators, things you think we could do to improve inclusion in your part of the pathway or parts that you study that others might not know about yet?
No, you go first. I'm pondering.
Okay. Well, one thing I would say is that, at lunch we were joking about, I was trained as an OBGYN, and we were joking about the fact that when anybody shows up in the ER who's pregnant, it's like, oh my God, get the OB here. We do not know what to do. I can take care of the GI bleed or whatever else is going on with this patient, but we got to get OB involved. And I wonder if that doesn't happen to a larger extent in the community in general. Because to go back to the example I gave, I think that to ask industry to conduct a study where investigators would include pregnant women without doing a dedicated study in pregnant women that has sites who have OBs who are managing these subjects, makes this set of investigators uncomfortable because they're contemplating that they're going to have pregnant people in their trial, and they're not sure how they're going to manage this. And so I think we would do well to try to break down those barriers and or to think forward about involving OBGYNs in the conduct even of trials that aren't explicitly designed to be done in pregnancy.
I can piggyback on that as well. Just at the FDA, I can say that I really admire my colleagues in the Division of Pediatric Maternal Health, like Layla and Lynn and other colleagues, because they're really ambassadors within the FDA to other divisions on this issue. And so it's like, while you're practicing medicine, you're like, oh my God, I have to go to the ED again. I think in this situation, actually, we're glad to help, right? Because that will facilitate the work.
And so one of the comments I wanted to make was that, I realized that I risk coming off as a Pollyanna because I'm like, oh, look at what we do at the University of Washington. But that is something that has taken leadership, not by me, leadership within the community as a whole. And it's taken, and it's not just one of those approaches that I mentioned, but it takes all of them working together. They are all of a piece. I think some of them are short-term solutions, some of them are long-term. On the short term, sure, add an obstetrician to your IRB so that you're getting the perspective, in the review process. But engendering that trust that our respondents were talking about takes time. It just takes time. And we talk about the Swiss cheese effect. I mean, in order to make it through all the legal barriers that Dr. Henry has identified, it takes, they can be stopped at any moment. This research can be stopped at any moment by someone's perception of risk. And it may not happen at the IRB. It could happen at the investigator level. Maybe they're not getting enough support. I mean, all the way through the research process, the pathway, all those holes have to line up for this research to be successful. And I think that's one of the biggest challenges in the law, is trying to touch on all of them to get you through the Swiss cheese.
That was perfect timing. Our 5 minutes are up. I'm going to turn it over to Dr. Cooper, who is going to lead us into the next session. Thank you.
They'll come up.